Welcome to Legal Minds. In my previous video for murder, I covered the actus reus. So if you haven't seen that already, I'll link it in the description box so that you can watch it in your own time. It is important that you understand the actus reus before you move on to the mens rea, otherwise you'll just end up confusing yourself. Now, as stated in the previous video, the final part of Lord Coke's definition of murder is concerned with the mens rea. So there must be malice aforethought, either express or implied. Now, I know the word malice connotes maliciousness and evil, but the word itself is not to be taken for its ordinary natural prima facie meaning, because to commit murder, the defendant doesn't actually need to have any ill will towards the victim, and the actus reus does not need to derive from any malicious feelings the defendant may have, because if that were the case, then people will be able to get away with honor killings, and killings, for example, where the defendant kills so that they can obtain something within their victim's will. Now, if maliciousness was a requirement, those people would essentially get away with murder. And in the case of Maloney, the House of Lords confirmed that malice aforethought simply means intention, and we can say that intention simply means motive or desire. Expressed intention refers to an intention to kill, and implied intention refers to an intention to commit GBH, so grievous bodily harm. And in the case of Crown against Vickers, it was held that the defendant doesn't even need to know they are endangering life when they commit the actus reus. So as long as the defendant intends to kill or commit GBH, he has committed the mens rea for murder. So what is actually meant by GBH? What will constitute grievous bodily harm? Well, in the case of DPP and Smith, it was described as really serious injury. However, in the later case of Saunders, it was held that serious injury was sufficient. And just to illustrate this point, in the case of Janjua and Chowdhury, a knife with a blade of 5.5 inches was used on the victim, and the court held that there was a clear intention to commit GBH. Nothing less could be accepted. And the injuries don't actually have to be life-threatening, and the meaning of GBH is largely contextual because the vulnerability of the victim can also be taken into account, as shown in the case of Crown against Vickers. And in that case, the victim was an elderly lady, and the courts held that the fact that she was an elderly lady could be taken into account. And so if the victim is particularly vulnerable, serious injury will have a lower threshold. A broken hip on a 25-year-old male can be said to be serious, but on an 80-year-old woman, for example, it will have a much greater level of severity. And the case of Crown against Burstow shows that psychiatric injury can also amount to GBH. In this case, the victim broke up with the defendant, who did not take the breakup very well. He began stalking her, ringing her up, and when she would answer, he would stay silent, so silent phone calls. He'd send abusive text messages, he'd wait outside her home, and the court held that psychiatric injury amounted to GBH. Now, I'm not sure how that would apply to murder, but it is worth knowing. Now, there's also something called oblique intention, which is sometimes referred to as foresight intention. And the classic example in every textbook given in every lecture is if A intends to blow up a plane because he wants to kill B, there is no doubt that he is aware that in doing so, he will also kill other people on board. That's not his motive or desire, he only wants to kill party B. But in doing so, he will be perfectly aware that he will also kill the other people on board. Now, the test for oblique intention was established in the case of Crown against Woolen. In this case, it was held that the jury should be directed that they are not entitled to find the necessary intention unless they feel sure that death or serious bodily harm was a virtual certainty as a result of the defendant's actions, and that the defendant appreciated that such was the case. All you really need to know from that is death or serious harm must have been a virtual certainty, and that the defendant must have appreciated this. So that's both the actus reus and the mens rea for murder covered now. In the next video presentation, I will cover the defences to murder.